So I would ask, like, when entering an international trade agreement or partnership, are there any specific IP clauses that companies should insist to protect their know-how or the proprietary information or from misuse or, I don't know, unauthorized sharing? Or so are there any key IP
Yes.
to think about to include in international trade agreements and partnerships?
Yes, there are. So there are certain parts that such agreements should have. There are different types of agreements. For example, you can have a company that has a factory in Macedonia and produces here and exports only sales through distribution channels in other markets. But you could also have a company that manufactures in a different country under a license and then sells from there. So each contract should have a clear ownership clause. So who owns what? Then it should have a clear licensing clause. What can I do with this type of ownership? And it should also have, this is something that I've seen very companies omit in the contracts, quality control clause. So what is the quality that you expect from your product? How do you expect this whole chain to close up until the moment the product goes in the hands of the end customer? And this is especially very important in cases when, for example, you make a contract with a factory in another country to produce your goods there and they'll sell them from there. You have to have a very, very strict quality control clauses. Because if they output a product that will have your name on it, they have to be associated with a certain standards and with a certain levels. And this is very important for companies that companies usually associate. I will connect this with trademarks. Trademarks with a defensive role. For example, I can defend myself if someone copies me with my trademark, but they rarely see the trademark as a proactive tool for revenue generation or for quality control. You can also franchise your trademark, and you can define a strict quality control rules that your trademark, anyone that will buy the trademark, that needs to comply with. This is very interesting and different perspective when you look in your IP rights, because their business purpose is much broader than only defensive. Even though the defensive and the blocking role is the first one, and we usually speak about that, this licensing part opens a completely new field of opportunities for revenue for companies. And it is the same with patents. There are companies that have their patents on very specific technologies, but they don't have the